Hi, in this lesson we're going to talk about estates in real property. So what is an estate? Well, by definition, an estate is the degree, quantity, nature, or extent of interest that a person has in real property. Now, we're not talking about the estate of a deceased person. We're not talking about a big country home as an estate. We're talking about what type of interest do you have in a property. And the best way to define that or think about that is just comparing owning versus renting. So most of us have probably rented, and many of us have owned property or do own property. So which of these two, owning or renting, is stronger? In which of these situations do you have a stronger hold on the property? Well, I think it's pretty obvious. Ownership interest is a much stronger hold, much stronger estate than a renter, than a lease interest in the property. And so we're going to actually talk about ownership interest, and that's what this lesson will deal with. And in another lesson, we'll talk about the leasehold interests. And that leads us to the two different types of estates. There are two categories of estates. There are what are called freehold estates. And make a note for yourself, the freehold estates are the ownership interests. So if you heard the term freehold, they're talking about ownership. Now, where did this term come from? Well, many of our terms here actually come from the Middle Ages, from merry old England, when only the free people, the free men actually, could own property, the noble classes. So by definition then, a freehold estate is an ownership interest in real property. The other category is a leasehold estate, also known as less than freehold. Remember, if freehold is ownership, less than freehold would be a leasehold estate. And again, in another session, we'll talk about the leasehold estates. Right now, we're only going to talk about the forms of ownership. So these freehold estates start out with what's known as the fee-simple estates. Now, this term fee, this comes from the old days of the fees and the fives and the foes and the fums, you know, from Jack and the Beanstalk. No, I'm only kidding. A fee, basically, that term has its origin as an interest in property. It comes from the Old English of a fiefdom or a fiefdom. And so this term fee-simple estate is an estate, an ownership interest, which is actually held in perpetuity, held forever. Now, the highest form of ownership is known as a fee-simple absolute. Now you see King Henry VIII there. Obviously, the king held fee-simple absolute. He was the ruler over all the land, and the noble classes, the landed gentry, they owned their property, but they were still subject to the king's whims and fancies. All right, so a fee-simple absolute is what I want you to remember about it. It is the highest form of ownership. The highest form of ownership. Basically, think about it as all of the rights of the bundle forever, in perpetuity. Meaning that you, just like the king, could sell your property, but if you decided you didn't want to sell it, you could will it, and your heirs could will it, and etc. down through the ages to their heirs. So fee simple is the highest form of ownership. It's the type of ownership, too, that you and I acquire in the ordinary course of business. And as a real estate agent, when you help people buy and sell property, what you will be transferring, what the seller will be transferring to the buyer, is a fee simple absolute. So again, it is all of the rights forever. Now there's another type of fee simple estate which is less than fee simple absolute. And this one is called a defeasible fee simple. This term defeasible, you've heard it before, means defeatable. In other words, the ownership can actually be defeated or lost. So you see a church there, just as an example. Let's say that you belong to a particular church and you wanted to give, or maybe sell, but let's say you gave this property to the church, but you wanted it to be used only for church purposes. what you could do is in the deed, in the documentation transferring ownership, you limit their use to church purposes. But then you say, if it ever stopped being used as a church, that ownership would revert back to you, or if you're dead, to your heirs. So the church's interest is fee simple. In other words, they have it in perpetuity, but only so long as they continue to use it for church purposes. If they violate that condition, it reverts back to you or your heirs. So there are conditions imposed on this property in the future which could cause ownership to revert back if those conditions are violated. It's called a defeasible fee simple estate, also sometimes called a fee simple on condition subsequent, conditions imposed into the future subsequently. So those are the two forms of fee simple title, fee simple estates, first one being fee simple absolute, the next one being this fee simple defeasible. So here's an example of a defeasible fee simple at church. The grantor, and remember, ownership is transferred by deeds, so there would be a deed which would transfer this, and the person who gives a deed is the grantor. The grantor executes the deed to the church, but for church purposes. If the church violates that condition, then it reverts to the grantor or the grantor's heirs. Now the next form of ownership, we're still talking about ownership here, is called a life estate. And a life estate is an ownership interest, but only for the duration of a certain person or persons' lives. So for example, let's say that I wanted to give my mom a property. I wanted to make sure my mom was cared for. Now I could give it to her fee simple absolute. But you know, my mom liked my brother a little bit more than she liked me, maybe. So if I gave her that property in fee simple absolute, when she passed away, she could will it to my brother. Well, I might not want that to happen. So what I could do is I could create a life estate for my mom, whereby I say, Mom, here, I give you this property. It's yours. You own it for as long as you live. But at your death, right, it comes back to me. We'll see a few examples of this in just a minute. Before we do that, though, my mom in that example, or whoever the person is that is the owner under the life estate, they're actually called a life tenant. Now, this term tenant, most of us think of as being a renter, but the term tenant also refers to ownership. So my mom in this case is a life tenant. And interestingly enough, one of the questions that comes up, can my mom sell that property or lease it to somebody else or even get a mortgage on it? Well, in theory, yes. But remember, she does not own an estate in fee simple. She only owns a life estate. So her rights in the property exist only for as long as she lives. At her death, that ownership terminates and comes back to me. So could she sell her interest in the property, sell her estate in the property? Yes. But the buyer would only be buying her life interest, and at her death, that buyer would lose that interest. So we don't see life estates being sold or leased or mortgaged very, very commonly. It's very rare that that would happen. But in theory, it can happen. But again, she's not selling fee simple, she's selling a life estate. Now, what she can't do specifically is she could not will her interest, nor could she commit waste. So by definition, she can't will it because it's a life estate. Secondly, she can't commit waste. What does that mean? Well, waste means the purposeful destruction of the property in some way which diminishes its value. So let's take a few examples. And you have some of these in your course, you have all of these in your course material. Let's say that I gave my mom a life estate. Oops, mom gets struck by lightning. All right, a little dark humor there. So what happens? Well, at mom's death, because of in the first example, her life interest would revert back to the son. Now, what the son had while mom had the life estate, the son held what's called an estate in reversion. So while mom is alive, mom owns the life estate. The son holds what's called an estate in reversion. This estate in reversion results in the reversion of the life estate back to the son at mom's death, and that at that particular point, the son holds fee simple title. So let's go back on this again. The son starts off with all of the rights of the bundle, fee simple title, conveys most of them, possession, use, occupancy, etc., to mom, but only for her lifetime. He still holds a right in the property. He holds this right of reversion. At mom's death, all of mom's rights come back to the son, revert back to the son. So that's example A. Let's take a look at example B. The son gives a life estate to mom, but instead of saying, Mom, at your death it comes back to me, at mom's death, it's specified that it's going to go to his sister at mom's death. Not back to the son, but on to a third party, the sister. In this circumstance, mom holds the life estate while she's alive, and sis holds what's called an estate in remainder. In other words, it's not reverting back to the son. If it was, it would be called an estate in reversion. In this circumstance, it's going on to a third party, not the grantor. That third party holds an estate in remainder. She is called the remainder woman, or if it were a man, he would be the remainder man. Now there's a third example we want to talk about. And this is one where the son creates a life estate for his sister, but dependent upon mom's life. So the son might say, hey sis, I'm going to give you this property for as long as, well, not as long as you live, but as long as mom lives. Take good care of her now. All right, in this circumstance, sis holds the life estate, but instead of being dependent upon her life, it's dependent upon mom's life. In this circumstance, sis is known as a tenant por otra vie, meaning the tenant or owner, in this case, for the life of another, a tenancy per otra vie. Now, in this unusual example, but you could see it happening, what happens if sis passes away before mom? Well, in this circumstance, the normal situation is that it would pass to sis's heirs, but only for as long as mom lived. In the situation where mom would more likely pass away before sis, then of course what would happen is it would revert to the son at mom's death. So this is a third example. It's called a tenancy per otra vie, where one person holds a life interest, but it's not dependent upon their life, but dependent upon somebody else's life. Now the last one, example D, is taking a different approach. Let's say mom owns the property in fee simple. Mom has fee simple absolute, and she wants to deed the property to her son, maybe for estate planning purposes, so she deeds a fee simple interest to the son. But she specifies, son, I'm deeding fee simple to you, but I'm reserving for myself, holding back for myself a life estate. So yeah, I'm conveying fee simple to you, but I'm going to keep the basic important stuff of ownership for as long as I live, and at my death, it will pass to you. Well, in that circumstance, since the son didn't give it away, it's not coming back to the son. The son holds what's called an estate in remainder. The son is a remainder man in this circumstance. So, those are the four different examples of life estates. We could even complicate it more if we wanted to, but clearly it's complicated enough. Here's what you want to remember. If the interest is coming back to the person who gave it away, that person has an estate in reversion. If the interest at the death of the life tenant is going on to another party, that person has an estate in remainder. Now, the last thing we want to talk about here is called a legal life estate. Those other types of life estates that we just talked about are called conventional life estates, created by one person for another. A legal life estate is actually a life estate created by law, by state law. And There are two of these that you may hear about or read about. One is called dower and the other called courtesy. A dower right is the right that a wife has in the estate of her deceased husband. A courtesy right is a right that the husband has in the estate of the deceased wife. Now, these do not exist in Arizona, but they do exist in a number of other states. See, Arizona is a community property state, and we'll talk about community property in another lesson. And community property laws are specific relating to the interest that a husband or a wife has at the death of the other party. But in some other states, when the husband passes away, automatically the husband's interest passes to the wife for the rest of her life, even though his will might say that his property goes to his child or somebody else. So in states that recognize these dower rights and courtesy rights, these actually create a legal life estate for the surviving spouse if the deceased spouse wills their interest to somebody else. Neither of these, again, exist in Arizona because Arizona is a community property state. So that's our discussion on estates in real property. And the only estates we talked about, of course, were the ownership interests. In another lesson, we're going to talk about the leasehold interest.